Supreme Court heard arguments Thursday on whether or not the Colorado Supreme Court ruled correctly when it scrubbed Donald Trump's name from the ballot, charging him with participating in an insurrection and thereby rendering him disqualified to hold elective office as stipulated by Section 3 of the 14th Amendment. Even though Trump led an insurrection, and any other civilized nation would have already locked this monster up, I always suspected the 14th Amendment disqualification was a long shot, but well worth the effort. You stop at nothing to defeat fascism because fascists stop at nothing. And that seems to be what most legal scholars are saying this morning. They seem to agree Trump should be kicked off the ballot, but they also agree the Supreme Court would never do that. They wouldn't allow it. The justices on Thursday, according to all the reporting, seem skeptical about throwing Trump off the ballot. You can interpret how an upcoming ruling is going to land based on the questions they asked during the oral arguments. Over at Lawfare, they write that the Supreme Court justices on Thursday seem to be focused on a very narrow reading of Section 3 of the 14th Amendment. And judging by their questions, their ruling will most definitely be an interpretation of Section 3, as well as the power of the states to enforce it. It will probably come down to whether Section 3 applies to someone running for president. Section 3 specifically forbids office holders from running for office if they participate in an insurrection. And it now looks like this court is going to quibble over the semantics of whether or not the president is an office holder. I know. As Lawfare points out, the Supreme Court on Thursday steered clear of the three consequential questions in this case. And those are, was January 6 an insurrection? Did Trump participate? And were his incendiary words on the ellipse that day protected speech? In my humble opinion, the Supreme Court is too chicken shit to answer any of those three questions because we know it was an insurrection. We know Trump led it, and we know telling thousands of heavily armed supporters to go and march on the Capitol isn't protected speech. He knew they were carrying weapons, mace, and he said, I don't care, they're not going to use it on me. We all know this. So the court is most probably going to punt, keep Trump on the ballot by focusing on the wording of Section 3. That's their way out. The old cop-out. Let the voters, not the court, decide whether Trump is an insurrectionist. That's going to be the ruling. 8th grade pablum. Let the voters decide whether Trump is an insurrection. Why are you asking us? We're just the Supreme Court. You know, for a court controlled by elitists, they sure are trusting of the mob. Meanwhile, Republicans in the House, led by Trump's bootlicks, Matt Gaetz, and the odious Elise Stefanik, who is married to a gun lobbyist, introduced a resolution co-sponsored by 60 Republicans declaring that January 6 was not an insurrection and that the states lack the authority to remove a candidate for federal office from their ballots. It's amazing. They can rule on whether or not January 6 was an insurrection, but the Supreme Court won't touch it. Elise Stefanik, who is part of the Republican leadership and auditioning for the role of Trump's running mate, told reporters, quote, as President Trump continues to dominate the polls, extremist Democrats stop at nothing to prevent Donald Trump from returning to the White House. You mean like storm the Capitol and prevent the counting of votes? Elise Stefanik is married to a gun lobbyist. That's all you need to know about Elise Stefanik, the Harvard-educated Elise Stefanik. She is married to a gun lobbyist.
It's time right now for the David Feldman Show. So get